Good evening, everyone. My name is Stephen Norman, and I want to welcome you to the Advanced Life Planning webinar presented by Attorney Ennis Jacobs Jr. Attorney Jacobs began his law practice after attending and graduating from FAMU and then later for the Florida State University of Law. He has practiced for close to 40 years and has been serving in the areas of energy, administrative law, environmental law, estate law, trusts, guardianship, and public law. Tonight, he is going to talk to us about advanced life planning. Advanced life planning is a topic that's very important because it helps us prepare for the inevitable. And it helps, and we become more concerned about it as we age and as we see our families age. And so we do it as an act of love. Without further ado, I'm going to turn it over to Attorney Ennis Leon Jacobs Jr.
Well, good evening. Okie dokie. Start my video. Okay. There we go. Says I need to see the host needs to enable my video.
You're not going to have video because you're doing a webinar.
I got you. Well, good evening, everyone. My name is Ennis Jacobs. I'm delighted to be with you today. I want to congratulate each of you for making a decision to take this time. A lot of people don't like to talk about some of the topics we're going to discuss this evening. But it is critical, and in fact, I think imperative, that we think about the latter stages of our life for several reasons, not just because of property, which is why most people think of it, but because of your care and your well-being, and we'll talk more in detail about those. So without further ado, we're going to try to move along fairly quickly today. We're going to do some preliminary type topics, and then we're going to get into some of the details. When I do this, too often the attention and the focus of attendees, they shift to want to talk about legal documents. We'll talk to some degree about legal documents, but really my approach always is to suggest, think about who it is you're dealing with, who are the people, including yourself, and then what it is you want what the outcome that you wish for those individuals, including yourself, and put that into a conceptual framework, and then start thinking about some of the technical details. So what do we want to accomplish tonight? Primarily, we want to build your awareness and understanding about the legal, financial, and aspects of healthcare as you age. We want to remove the mystique that surrounds this area. So often in the latter stages of our life, our decision making is surrounded by fear, trepidation, and lack of information. I see that so often, and too often it leads to poor decisions. And so hopefully we can bring some information and wisdom to you today, so that you're not making decisions based on those unpractical factors. But probably for me, the thing I would hope you'd come away from this probably more in detail is the understanding what it really means to have life to the full. That scripture is so important, and I'd love to read it. John 10:10, it says, the thief comes to steal and kill and destroy. I have come that they may have life and have it to the full. This verse is often interpreted to mean that Jesus came to give people a rich and meaningful life, a full life for all of their life, filled with joy and purpose. Not just or necessarily a long or an easy life. You'll have challenges. but you can overcome those challenges. And that's we hope to give you some tools and opportunities to do that. Proverbs 4:23 says, keep your heart with all vigilance, for from it flow the springs of life. This verse suggests that the health of your inner life is the source of your outer life. So the more you can be at peace and have understanding, the better you're going to be able to take care of your estate, your outer life. So let's dig in. Uh, there are two main areas we'll cover today. One is called advanced care planning. The other is called estate planning. Now, there's another area that's a subtext here that's called long-term care planning. That really is an umbrella over this, and we'll kind of cover some of the topics that are related to long-term care as we go through this. But we want you to come away with some clear understanding of what these areas are, how they affect you, and what you can do personally to address issues in these areas. So I must give a disclaimer. I am an attorney, but I am here purely as an instructor today. This is not intended to give you your specific legal advice for your circumstances. Hopefully this information will give you some very strong conceptual understandings, but then for your specific tactics and plans and documents, you need to seek specific legal advice from someone trained in your particular community. That's really important. Now, let's talk about advanced care planning. So this area is kind of subletting into the idea of emergency care. What happens if you are taken by some unplanned urgent situation? What resources, what directions are in place for you, anyone who cares for you to deal with that? Is there some way of them even to know that you have encountered an emergency situation? We're going to think about that and give you some resources for that. Now, but without question, the issue that is becoming a crisis, I believe, not only in our state but around the country, is elder care. I started out in my practice doing mostly. I thought I was going to do just primarily drafting wills and going to court and doing the probates and guardianships. I do that. I do a lot of that. But what I'm understanding all too often is that there's a stage that comes before that, and how you deal with the issues surrounding your elder care have deep and dramatic impact on what happens when you start doing estate planning. So that's why I put it in such a high level on the ladder. How you think about, how you reference your end of life stages is so critical. Who it is you're thinking about, and what do you want to accomplish with those people is incredibly important. I could go on with stories and stories, and I've been known to go on with stories about situations that I've seen. But let me just address one of the best circumstances I've seen. I've had the privilege of being a legal advisor to a family in North Florida, and very close-knit family. They came together and understood that they wanted to take care of their parents in their house. And so it's a brother and a lot of sisters. So maybe that he kind of became the head leader of it all. I don't say that for any reason other than that's just the way it happened. But this family came together. They had a farm of 40 some odd acres. They put together a plan for how the land was going to be handled. They went out and actually they built a house on the family land. Each of the siblings has a room in the house, and only one of them lives there. The others live in remote places. But the plan was they're going to have their own room when they come to take care of their mother. In addition to that, they hired an in-home healthcare provider for their mother. So somebody's there 24/7 with their mother, and then they'll come and relieve that person in turn. And they schedule when those turns are going to be. Every major holiday, they're gathering at that house. It is one of the most delightful experiences I've had to deal with that family. There's none, but there's all minimal confusion or disillusionment. They all understand what they're trying to do and what they're trying to get done. That's an incredible example. On the flip side of that, I had the red flag for me when it walks in my door is a blended family where you have a individual who's there's been a separation of one marriage and they've remarried. That, without question, raises the red flag for me because too often there are complexities, both emotionally and technically, and how property gets handled. We'll talk about that a little bit more. So I say it now: if you're in a blended family, this is definitely for you. You want to think about some of these issues that we want to talk about. Now, one of the specific things, other dividing lines is tactics you take while you're living, and then tactics that you take that take effect after you're no longer living. So the first thing we want to talk about is something called advanced directives. Um, these are decisions that you make of tactics that are to be taken while you're living, but you probably have of diminished capacity. You don't have the ability to go pay your bills. You don't have the ability to make decisions or go to the bank, and you need somebody to do that for you. So let's dig into that real quickly. Um, so let me, I guess I covered this, but let me just cover this again briefly. Elder care is a broad term. It covers services that support older adults and maintain their independence while they're living. It's a wide range of activities that are covered. It can be provided in a variety of settings, including at your home, at the individual's home, at a community center, senior citizens, or residential facilities. What types of elder care support are there? First of all, you have daily living assistance. My wife, I think, is on. She is doing this service for a lady right now, where she goes over, helps her with a basically just personal care task. Um, you can Another setting would be in a medical and skilled care facility. Another relative right now that's had a long-term illness and they're in a medical facility. They're having some complications because they've been there so long. We'll talk a little bit about that. But this includes services like skilled nursing, physical and occupational therapy, and such. Sometimes you have a lot of capacity and you're able to do a lot of things, but you're alone. And so you can just have somebody who's providing you companionship, social and emotional support. 9 times out of 10, there's going to come a point, and sometimes a forced point, where you can no longer transport yourself. I can't tell you how many families struggle with this idea of when to tell their elder relatives to stop driving. Sometimes it becomes a real challenge. It's always good if you guys can come together and agree on that, and then, but more importantly, provide some plans for how you're going to now live now that you don't transport yourself. And then finally, community services like adult care. I want to encourage you to look more at these kinds of services for your elder citizens. It's becoming, the evidence and the data is showing clearly that the more you can keep an elder person engaged emotionally and mentally, the better off their physical health will be. So if there's a daycare, adult daycare, a senior citizen center, meal delivery, those types of services are very helpful, and they carry long-term impacts. So what are the settings that you have? You can, like as indicated, you can have in-home, you can have an assisted living facility, you can have nursing homes, which is one of the most problematic circumstances. We'll talk about more, and you can have continuing care communities. These are growing in popularity, continuing care communities. We won't dig deep into the details of these today, but I want to make you aware of them so that you can do more research in your local area to see what they're available. An area that I'm really using more in my practice are memory care units. I'm seeing more and more dementia cases come to me for guardianship. A gentleman come to me, his mother was living alone, and suffered a deep decline, a quick and deep decline into dementia. So much so, and she would not go into a facility. She and that we'll talk about that more in a moment. But she insisted that she wanted to stay in her own house, and wound up setting fire to the house in her dementia to burn it down. So you want to seize upon early as possible when you see indications of memory lapses. You want to figure out if there's some assistance that can be provided by one of these memory care facilities. Who provides elder care? Family members, professional caregivers, and medical professionals. It's really interesting. Before all this Medicaid shenanigans, Medicaid was moving very much towards what we're going to talk about just next is care in home, and Medicaid. I'm sorry, Medicaid. Medicaid was moving, not Medicare. Medicaid was moving very much towards that direction. And under Medicaid, if you approved for in-home care, you could actually pay a family member to provide that care. But you can also have professional caregivers as well as medical. So that process that I was just speaking about is called aging at home. There's growing body of evidence that's very clearly states that uh, it is exceptionally more likely that an elder person will have, first of all, a higher quality of life and more meaningful quality of life if they can stay in their own home versus going to some kind of facility. And so, for that reason, a lot of the senior policy, and particularly Medicaid, has been moving towards facilitating aging at home. It's when the older adult can remain in their home and in their community for as long as possible, rather than relocating to an assisted living or an institutional setting. However, this will require some important and specific planning. Uh, Another case that I had, uh, uh, it was incredible. It was a blended family, and the daughter the daughter and the second wife, of course, had issues, and the wife wanted to keep her elderly father. I think he was in his mid 80s at home. He's clearly was going into dementia. They were living in a two-story house. They had no real facilities in place. He had to go up and down the stairs, taking showers and such, and they had no in-home care. And and the daughter was had hired me to try and deal with that situation. And that's because the wife is the primary custodian. We had incredible difficulty trying to get the courts to intervene with any kind of way to impose some of these kind of resources for that man. So how to support aging at home? Plan ahead, very much, and it's best if the individual who can do it for themselves. In other words, it's best if you think about this idea well before you fall into decline, and you put in place your plans, and you tell your family, here's what you want. And we're going to talk a little bit more about how you can do that. But it's best if you put together a plan, or go and consult with some people who are expert, and we have some resources that we'll share with you that will allow you to do that. But it's best if you do that rather than somebody doing that for you. Make decisions about your future. Then, once you make that decision, then look at your circumstances, and make plans according to where you are and how you are. That might include installing infrastructure in your house, lighting, widening your hallways. A lot of people don't realize how important that is. But if you become immobile, that's a critical need that you'll have. Use technology. That is becoming almost a pervasive new trend. Where and I've seen in several cases where a child would install security systems with cameras into the home for their elderly parent, and they live miles away, but they can monitor the moment by moment what's going on with their parent. The parents don't like that, but again, this is a matter of you sitting down and making a decision. If you're going to stay at home, this is the kind of support you need. Now, how do you support how aging at home? Again, you can arrange for home care services, uh, transportation, meal delivery, health care. Now, I want to bring in a subject here real quick. So, this is an issue I see very often. If you are an individual that's already a Medicaid enrollee, not Medicare but Medicaid is generally, and you become eligible for Medicaid according to your income. And most states have a threshold. Here's how much you can make and still be eligible for Medicaid. Well, if you retire on a pension and you get Social Security, you're almost automatically going to exceed the Medicaid threshold. I would be surprised if you live in a state where you have a pension and Social Security and you don't exceed the threshold. And so most people just walk away and say, I'm sorry, that means I can't take advantage of these Medicaid services. But you can. There's a process that I've done very often where you can set up something called a qualified income trust. Qualified income trust. Again, you need to go to a professional, go to a Medicaid counselor first and get full understanding of what your eligibility for Medicaid is like. And then once you understand that this process will work for you, go speak with an attorney or somebody who's an expert in this to understand how you can set this up. What that is you go you manage your income. The Medicaid will allow you to keep in your personal bank account up to the Medicaid threshold for your state. But then everything over the Medicaid threshold has to go into a trust account called the qualified income trust. So you put that in every month. That money, you don't lose access to that money, but that money becomes a restricted access. You can use it probably for most of the stuff you would have used it for all along. Your bills, your medicine, your personal care. The money in your qualified trust can most often be used for those types of elements. You can't use it for your cruise to the Bahamas. Now, in your personal account, you can, but that's going to be limited income, remember? So, that's a real important point that if you want to stay in your home, you can take advantage of the Medicaid in-home long-term care provisions, but you'll probably have to take advantage of them through this process called qualified income care. Let me see how we're doing on time. Okay. Next. So now let's talk about some of the tools to do some of this. Now, again, this is pretty much why you're living. These are some of the tools that you're going to take advantage of for elder care. The first thing is called a durable power of attorney. Durable power of attorney is where you appoint a person normally called an agent, and they are to take care of your pretty much your business affairs, your financial affairs, because you are lacking capacity to do that. So obviously, this person should be somebody who you are fairly confident is responsible and trustworthy. Because if you sign this document appointing them, they can go and write a check on your bank account. Now, what a lot of people do, and this is let me be very careful about this. What a lot of people do, they don't do this. I've seen this time and time again, and I don't mean to demean you because it's a common practice. They know that they're beginning to fall in capacity, and they know they're going to need some help taking care of their financial affairs. So they'll pick out somebody, normally one of their children, and they'll just simply make them a co-owner on their bank account. And so at that point, once you make them your name, their name on your bank account, they now are a part owner of that account. So they can write checks on that account. But there's a double-edged sword to that. They are a part owner on that account. So that it's an asset. If they go into bankruptcy, that bank account becomes an asset in their bankruptcy, at least half of it. So I always advise people not to just go put their child on their bank account. Execute a durable power of attorney and appoint that child as your agent under durable power of attorney. And that way, none of their issues feed over into your issues. They're only your agent, so none of their financial issues feed over into yours. And they can only do what you say in that power of attorney agreement. The next one here, for conceptual purposes, is a healthcare power of attorney. It's called designation of healthcare surrogate. Most times when you go to the hospital, particularly when you're elderly, they're going to ask you, do you have? They don't call it this. Many of them call it I can't think of the name but what they're asking for is whether or not you've designated someone who can make healthcare decisions for you in the event that you can't. So you can execute this, and again, you would appoint somebody who, if you're under anesthesia or you can't make a decision, the doctor can go talk to this person, and they'll make a decision as to what should happen with your health care. Again, you should make sure this is somebody that's responsible, who has a reasonable in their thinking and judgment. And then the last one is a living will, which is probably the most wrong name they could put on a document. A lot of people think this is saying I want to tell somebody how I want to be taken care of while I'm living. No, the living will is where you make end of life decisions, i.e., do not resuscitate or not. It's separate from the healthcare surrogate because it's such a highly charged issue. So you may or may not want the person who you appointed your healthcare surrogate to be sitting, because what's going to happen, I can tell you time again, is the whole world is going to crash in at that moment where the decision is whether or not to pull the plug or not. And you want to make sure that you have somebody who can stand that kind of scrutiny, that kind of pressure, to sit and hear the input and then make the decision whether or not to pull the plug or not. That's what the living will is. You appoint somebody who makes that decision. Okay. Now, there's a great resource that I'm going to recommend to you, and we're going to pause for just a minute for some questions. There's a great resource that I'm going to recommend to you. It's called Five Wishes. This is the organization where you can go and basically write up some of these issues that we just talked about. I view it as sort of a living. I wouldn't use it as a durable power of attorney. I would still have a durable power of attorney, but if you do a five wishes, you should be able to avoid doing a living will. But you can also make some other decisions in there. How you want to be treated while you're in hospice. What do you want? If you want somebody to play some music for you while you're in hospice, some particular music, those kind of things that you can put in your five wishes plan. I highly encourage you to go pull it down. It's online. Read through it, and then if you choose to, execute it. Okay. I'm going to skip through this very quickly because I really suggest that you go talk to a Medicaid counselor to get the finite details for this in your where you are. But that is identify what eligibility. We talked about this already. What the eligibility requirements are for Medicaid in your state. How to do that qualified income trust that we talked about. Uh, but here's the area that's really interesting here. Once a lot of people don't understand what Social Security SSDI is and what SSI is. SSDI is when you have a pretty much a historical disability beyond 12 months, so you can't work or anything. That's when you look at SDI. SSI is kind of retirement or a temporary disability. Okay, they come from similar pots of money, but not exact pots of money. But they're pretty much when you can't work because of some ailment. All righty. All right. So we'll pause here for some questions, and I think you're going to submit those questions to Mr. Norman.
All right. If you would type in your questions in your Q&A at the bottom, I have one question. Will you expand a little bit more on the qualified income trust process?
So I recommend that you think about this before you need it. But to go right to it, this is only about you becoming eligible for Medicaid. Okay, and generally it only becomes necessary if your total household income or your personal income, maybe not your household, but is over the threshold in your state for Medicaid eligibility. Remember, Medicaid is income qualified. So generally what I find is that if you got a pension and you're getting Social Security, you're going to be over the Medicaid threshold. So without anything else, you don't qualify for Medicaid. So this process is purely to get you qualified for Medicaid, and it's a process that the government has allowed. So what you do is you draw a line in your income at the Medicaid threshold. So, and I would try to do it like $50 or $100 less than. So like draw a line at like $100 less than the Medicaid threshold in your state. And that's the amount of money you're going to keep in your personal account every month from all your income.
All
Then
right.
everything over that is going to go to that trust account, and it's managed. You can use it for specific purposes. And again, go speak with a Medicaid counselor to make sure what the purposes are that you can use it for. But again, the primary issue is so that you are now no longer getting the income that exceeds the Medicaid threshold in your state.
All right. Are there any other questions? Just type it in the Q&A box at the bottom of your screen, and we will seek to answer it. What did Joyce McGlory had posted that question? That if you want him to follow up on that, just type it in. Henry James, is the designation of a healthcare surrogate the same as advance directive?
It is a one form of an advance directive. Generally, the power of attorney, the healthcare surrogate, and the living will are all commonly termed as advance directives.
All right. If a person is diagnosed with terminal cancer with a life expectancy beyond 12 months, would they qualify for SSDI?
I am absolutely not qualified to give you an answer to that. Um,
Okay.
I would encourage you to go speak with a social either a counselor or a Social Security office.
All right. In that state. Okay. Any other questions? All right. If there are no more questions, we will move ahead.
Okay, estate planning. There are so many avenues to look to think about here, but again, I want to go back to my first comment. When I sit down with people who want to address this topic, I always say, okay, what is it that you want to deal with? Okay, why you want to deal with the house, the land, the investment account? Who is it that you want to deal with it? Think about those issues before we even start talking about specific kinds of tactics, strategies, and documents. Okay. Um, Classic example. I have a family. They have 200 plus acres, and what used to happen is, and the smart individuals, the father and the mother would they would do a deed, and that while they were living, they would deed that property over to all their children, so all their children become equal owners of the property. Okay, but then the children say we got properties. They don't do anything. They don't do a will. So I have that family has these 200 acres. The father and the mother deeded to four of their children. The fifth child they gave some other land to, but neither one of those. I take that back. One did do a will, but other ones did not do a will. For their entire life, they passed away. Now their children, the grandchildren of the original owners, are now figuring out what to do with that property. In order to go back and deal with the title to that property that was in the name of the four children, I've had to probate all three of those estates because the title is all three of the. It's called undivided title. So the title is sitting in all three of their names, all four of the names actually. One of them had a will and they had done their estate. So we had to probate. I had to do three estates in order for them to reconcile the title for 200 acres. And then they couldn't agree on how to do it. That's a story for another day. So if you don't do some planning, this thing called heirs property has plagued African American families for decades. It is how African American farmers lost most of their land, those who got land, but most of those families lost so much of that land in the South because the original owner he may have deeded that land to his children, but his children didn't do much after that. And so you have land that's sitting around that's in the name of somebody who's been dead for 30, 40 years. You can do nothing with that land because it's titled to somebody who's deceased. The only way to deal with the person's property once they're deceased is through a legal process. And it's called probate. Now, if you do, you can have either you can exercise your own directions about how this probate will happen. If you don't, the law, most states have laws called intestate laws that determine how your property will be handled if once you're no longer living. The problem in so many African American families is that they do nothing. They don't do probate for one or more generations. And so the title to that land sits there. And so what would happen is I guarantee you go most county courthouses, there's people sitting in the title records room looking for property like that. They'll find the property that's what they call heirs property. They'll find that it's owned by a black family that's not getting the loan. They go find one member of that family who's disenchanted, and they say who didn't even know that probably that they had interest in this property. They'll go. They say, "I have a deal for you." They'll pay that person for their interest in the land. That person would deed over, never having seen it, or maybe never seen it, may have seen it, didn't know what it was about. But they'll deed over their share in that land. Now you can do nothing with just their share, okay, alone. But what those people will do, they'll go to court and start something called a partition. I won't get into all the gory details. The bottom line of it, when you do a petition, you can do a forced sale. So that one person only having one sliver of the interest of that property, and everybody else is sitting around with theirs thinking that they're all good. that one person will go to court and file for a petition, ask for a forced sale, and will require that land to be sold. Now, guess who's going to step up and try to buy that land once the court says it should be sold? I'll leave it to your imagination. Okay. The other fallacy that I've seen in so many African American families is somebody in this situation with heirs property, somebody will keep paying the taxes. That's in fact that's how it gets to be heirs property, because if you don't pay the taxes, then there's something called a tax deed. Somebody will get a tax deed and they'll take the property. So somebody in the family keeps paying the taxes on the property, and they think that because they paid the taxes, they now can get ownership of that property. That's not the case. You can pay taxes for all the years that you're alive. You do not have legal right to the title of that property. The only way to deal with the title of that property is through the probate process. Now, what you can do, you can get reimbursed for the taxes that you paid, but you cannot take ownership of that property simply by paying the property taxes in the name of somebody who's deceased. That's a great misconception in many families. So estate planning is where you sit down and you figure out how to do that, hopefully while you're living in sane mind and while you can get some cooperation from other members of your family. Now, what I just talked about, the main avenues, that's called the probate, is called judicial property administration or estate property administration. Okay, that's if you do a will. In some cases, we'll talk about a trust, but most often it comes about if you write a will that says, here's how I want my property to be distributed after I'm no longer living. And by the way, let me go back for a minute. All the advance directives that I talked about, that document's effect terminates at the moment you take your last breath. So a power of attorney, healthcare surrogate, all that is no longer affected the moment you take your last breath. So if you appoint somebody a power of attorney, they can do nothing once you pass away. The only way your property can be dealt with once you pass away is in a probate process. Okay. Now I take that back. As soon as I said that, I realized we're going to talk about some non-judicial ways you can manage your property after you're living in a moment. But for now, the main way that most people think about is they say, I'll do a will, and that's how I'll manage my property once I'm no longer living. When you do a will, that will can only be made effective in a court proceeding. So what happens is when you pass away, they take your death certificate and the original of your will, and that has to be presented to a court. People show up and say, I'm interested, I should get something out of this will. The court looks at it, makes sure everything's in line. If need be, it holds a hearing, and then they distribute the property according to the terms of that will. As I said earlier, if you did not have a will, there's a state law called intestate that will determine how your property gets distributed. Okay, you should look at how that's structured in your state. Okay. Now, you can't just write up a little handwritten note and let that be your will. And I've seen it. Some people have tried that. It can be handwritten, but it needs to be very formal handwriting. Probably should be typed, clear and distinct writing. Should have formal executory language. What I mean by that, I have this property. Here are people who are my heirs who I want to get this property, and here's what they get. It should be very clear, very formal. You should get it executed in a very formal manner. Most states require that you go before a notary and 2 witnesses, and those 2 witnesses will swear that when they saw you sign that, you were in good mind, and you knew what you were doing, and therefore that will represents your true intent. And then once, so now you pass away, that legal will now goes to a court. Normally, in most states, the court will open up a legal proceeding. It will the judge has supervisory authority over the whole matter, but the judge is not going to do the legwork. They're not going to go open a bank account, put your money in. So they appoint a person. In some states, it's called an executor. Some cases, it's called an administrator. Florida is called a personal representative. If you have a will, you name who you want that to be. They're going to do the legwork in the probate process. If they got to find where all your property is, they're going to go talk to people, go talk to the banks, figure out which bank has what money. Then that money gets brought into your probate case. Your cards, they got to get which cards you own. So you ought to know who that person is, and you ought to make sure they can find. That's a big problem I have. You name a person represented, but they don't know where your will is. They don't know where your titles to your vehicles are. They don't know nothing. All they know that you told them to be the person representative. It's a tough job if that's the case. So if you're gonna name somebody to be your person representative, you ought to give them a copy of your will, and you ought to identify for them how they can find your information. We're going to talk about that a little bit more in a little bit. Okay. Now, once you open up the probate process, the court needs to know exactly what you're talking about. You got to do an inventory. And that inventory should spell out what your land or your real property is, what kind of personal property you got, vehicles, appliances, what kind of intangible property you got, financial investments, etc., and then what kind of collateral property you have. Now, here's a big fallacy that in Florida. Well, let me say this. Now, if you had debts when you passed away, those debts don't just disappear, but they're restricted. In Florida, the law identifies certain assets that are exempt from creditors. I think your homestead, the house that you're living in, I think $20,000 in cash and 2 vehicles. So your credit card company can't come to court and say you owe them money on your credit card and force whoever your heirs are to sell your homestead to pay your credit card account. Now, but you got rental property and rental income, that's fair game, but not your homestead. Personal property, vehicles, appliances, and such. Now, here's something that's really important: collateralize. So let's say you got a car, but you got it's still on the installment note. That lender who loaned you the money has a lien on that car. That lien is not washed away under probate. Because it's a legal attachment. So they can claim their lien even if that car is exempt. Same thing with your house, your homestead. If you have a mortgage on your house, when you pass away, even though the homestead is exempt from other creditors, it is not exempt from the lender that has a lien on a mortgage. First thing I tell, and I've seen several situations where a young couple, one of the spouses passes away. First thing I tell them is, you're in shock. They got a lot of stuff going on. Go to your mortgage company and get what's called a forbearance. Forbearance is basically a grace period. Many times in that situation, the lender will give you 5, 6, sometimes even a year, rarely, but they'll give you some grace period to pause your mortgage payments until you can kind of get your emotions back together and your finances back in order to keep that mortgage going. Do not think that mortgage goes away. If it does not, and they will. I've seen it. They will foreclose after a person passes away. Okay, now, so let me go back to this for a second. So now you open up the probate case, you do the inventory, you get all this stuff in front of the court. What is incredibly important is to hopefully get everybody on the same sheet of music. If there's going to be somebody who's going to challenge the will, I can tell you that's going to cause all kind of confusion. And again, the red flag is the blended family. That it gets so much more complicated with a blended family. If you got a blended family, I'm going to almost insist that you do a will and that make that will very clear and very specific. If you are not giving property, if you're giving property to one set of children and not to another set of children, your will needs to say that. Okay, very clear and very specifically. And y'all need to work that out because they'll come and challenge the will. If you're going to set up a trust from your will, that needs to be very clear. And again, we'll talk more about trust in a moment. But if you're going to do some of these sophisticated things of managing property, sending property to an LLC, get very detailed and very specific in how you do that. Now, some non-judicial estate planning strategies. So one of the most common ones I suggest to people, most people, we're modest people. We got a bank account, we got a car, we got a house. We may have an investment account, a small 401k. What I suggest in those instances is particularly if you don't have a whole lot of heirs, maybe 1 or 2 children, is think about this process of non-judicial estate planning. And what that really means, on your bank account, you can, on your bank signature card, you can go to the bank and say, I want to make this what's called a pay on death account. Okay, it's just like a life insurance policy. When you open up a life insurance policy, what you normally do is you buy the policy, you own that policy, and you make the premium payments. But then you identify the beneficiaries, because in a life insurance policy, you know the proceeds are going to pretty much get paid out after you pass away. So you identify on that policy who you want your pay on death beneficiaries to be. And so when you pass away, your life insurance agent, all they need is a death certificate, and they cut a check to whoever you name as the beneficiary. You can do that same thing with your bank account. You can go to your bank and on your bank signature card, say, I want to name these people as my pay on death beneficiaries. While you're living, only you have access to that account. You can do everything you want with it. You can drain it. So so it doesn't make a difference if you have pay on death beneficiaries. But if there are proceeds remaining in that account when you die, on the day you die, as soon as they can get a death certificate, those pay on death beneficiaries can go to that bank, and that bank should release those funds to them. That's really important because a lot of times, even if you do a will, you got to go to court before those funds can be available. So a lot of people do this because you're going to need, there are going to be expenses, final expenses that have to be paid. So that even if you do a will where you distribute, they do a pay on death account so that somebody can get access to pay final expenses immediately. You can do the same thing with financial accounts. Most investment accounts, you can name beneficiaries as pay on death. So I highly encourage you to do that, particularly where you have modest assets and there's just a few people that you want to deal with. Now, let's talk now about something called a life estate deed. This is something that I recommend a lot of times. This only has to do with real property. So many times, and it's pretty much the same set of circumstances that I just described. You don't have a lot of land. You have pretty clear definition of how you want that land to be transferred. While you're living, while you're in sane mind, and you can sign a formal document, you can do something called a life estate deed. What that deed says, I'm going to keep ownership of this property so long as I live. That's called the life estate. But the moment I pass away, I'm going to name somebody who this title automatically transfers to. That in that situation, those people don't have to go to court. They don't have to go to probate to transfer title to that land, because here's a deed, a formal document that identifies how the title gets transferred. So if you do a life estate deed on a piece of property, all that person has to do is take your death certificate, file at the courthouse, and they should now be the owners of that property. You don't have to go to probate to do anything. Now, I know I'm running a little bit long on time, so I'm going to move a little quickly here. What I always recommend with a trust, generally, a trust is most beneficial when you want to have some control over your property after you're no longer living. Now, a lot of wealthy people use them for strategies, very sophisticated strategies while they're living. If you got a lot of assets, you're very wealthy, you want to go sit down with a financial manager and an attorney to manage that. I cannot give you good, clear directions about how to do a trust for that. But there are some narrow situations where you might want to do a trust. One of those is have something called asset protection. Most times, if let's say you have to go to a nursing home, no, you don't have any options to stay at home. If you go to a nursing home and you don't have a long-term care policy, insurance policy to pay your nursing home expenses, they're going to make you pay from your assets. And I don't care what those assets are. They call it spin down. You got to exhaust all of your assets. And then once you exhaust all your assets, then you can go get qualified for Medicaid. Okay, so that means if you got land, if you got bank accounts, investment accounts, they're gonna make you liquidate all of that and pay it to that nursing home in order for you to stay there. If you don't, then you can't stay at that nursing home. And I'm going through that situation right now with somebody. Okay, so one of the things I've seen with trust is people use it to become paper poor. If you transfer all your assets into a trust, you no longer own those assets. The trust becomes the owner. The trust is a literal legal vehicle, and it becomes the owner of that property. And the federal process if has what's called a 5-year look back. So if you transfer all your assets into a trust and then 5 years expire, you are paper poor. They do not look to those assets to determine your eligibility for Medicaid. You can still pay your expenses out of that trust, but you can't get that income from those assets. So let's say you put all your assets into a trust, you got to go into a nursing home. Your trustee can pay your nursing home expenses from that trust, but you're now still eligible for Medicaid. You can be at home and get those benefits. So that's what's called asset protection strategy for doing a trust. You and for people who are not extremely wealthy, I recommend that if you think that there's a strong possibility that you're going to have to go to a nursing home because you don't want to exhaust all your assets to a nursing home. Another vehicle for a trust is something called a special needs trust. And that's really not, it's sort of estate planning, but it's not really. Normally, when a person is already in Medicaid, okay, you're a Medicaid recipient, and for some reason you come upon some unexpected cash infusion. I had this situation, a lady, she had chronically ill, on Medicaid, and one of her relatives died, and she was a beneficiary in that relative's will, okay? So she was going to get money from the state administration of her relative. Well, if she'd have got that money in her hand, it would have kicked her off of Medicaid. Well, you say, okay, that's okay. That need, if you're in Medicaid, your medication, your hospital expenses, that's taking care of a lot of your medical expenses. It ought to be a lot of money that you get that you allowed to kick you off of Medicaid. So what you do, you set up this special needs trust. And it's similar to it does a similar function as what a qualified income trust does. All the money that's coming from this source of money is going to get put into a special needs trust. You don't lose access to that money, but it's for restricted use. And I would suggest you go speak to an expert who can tell you what those uses are. But again, it's probably going to be your utilities, your medication, and such. As long as you keep that money in that special needs trust and you don't take it to do anything else, you don't use a vacation or something, you keep your Medicaid eligibility. And so a lot of people don't know this. And so they take that money and they get kicked off of Medicaid. You don't necessarily need to do that. You should go, if that situation happens, you should definitely go get advice on that. And then there's another one I won't talk about now in the interest of time. All right, so let's close this section down. So the non-judicial, we just talked about life estate deed, something called right of survivorship. So if you get in that situation I talked about a few moments ago, where the parents deeded the property to 4 children, that's like each one of them is a line of ownership. It's called undivided. If one of them dies, that line of ownership goes to their heirs. If you do this magic thing called right of survivorship, if one of those 4 died, it doesn't go to the heirs of the person that died. It lapses into the remaining 3, the remaining owners, until the last one is living. So that's what a right of survivorship does. We talked about death beneficiaries. Okay, we'll pause here for some more questions. No questions? Are you there?
Yes, I'm here. Will you give examples of physical or mental illnesses that would qualify for SSDI?
Again, I'm not the expert there, but I'm pretty sure dementia, Alzheimer's is one of them.
All right.
But you got to have a diagnosis.
Okay. Can you speak about the irrevocable trust?
Okay, good. I did skip over that. So when you talk about a trust, there's two flavors, 2 main flavors. There are actually others, but the 2 main flavors that people hear about is a revocable trust and an irrevocable trust. Not that simple, not that complicated. A revocable trust is when you form the trust for whatever purposes you want to form it for while you are living. And you form it with the clear intent that you want to keep the flexibility of changing what's in that trust. while you're living. So you create the trust, you lay out in the trust agreement all that you want to lay out in it for it to do. And anytime, and you put in there provisions that anytime you want, you can come in and revise those terms. I had one lady, she did her trust, and then she got mad at one, I forget who the beneficiary was, I think it was a child. And she came in and X'd them out of the trust. So beware. Uh, Irrevocable, obviously, is different. You create an irrevocable trust. It means once you sign on the dotted line and make that trust effective, you can't come back in and revise it. Okay, that's basically the difference.
All right, I have another question. How does joint marital accounts fit into the discussion?
I'm assuming you're talking about joint marital bank accounts. So, let's say you and your spouse are joint on an account. Uh, and this is interesting. I didn't know this until the last few years. There's a term of art called, not a term of art, it's a legal term called tenancy by the entireties. Okay. So normally if two people are on an account, name one, comma, name two, they are both undivided owners of that account. If one of them passes away, their ownership interest in that account pass down to their heirs. So, and now you can do right of survivorship on an account. So in that event, if one of them passes away, then ownership automatically passes to the other person that's on the account. Tenancy by the entirety takes us to that concept to another level. And it only is invoked when you take ownership of an asset and comma husband and wife. It's the only time a tenancy by the entirety happens. So you open a bank account, comma husband and wife. You buy a piece of property, comma husband and wife. Then you form a tenancy by the entirety. What the law in that instance says, it doesn't even see two people. It's only one person. That married couple. So if one passes away, nothing changes because it was only one person that owned the property. Okay. And this is very, very important in a blended marriage. I've seen this time and time again. Second marriage, couple buys a house, husband and wife. Okay. I have this right now. And the children of the first marriage think that they should get something out of that house. Not happening. If that in that second marriage, they buy that house, husband and wife, they were that was one entity that owned that house. One spouse passes away, the other spouse owned that house free and clear. Children of the first marriage get nothing out of that house. In Florida, they can't even get it if even if they write a will, because in Florida, you cannot deed away the homestead from the surviving spouse. That may be the case in other states. So they're totally out of luck.
All right. Does the right of survivorship provision need to be in an irrevocable trust?
Well, I'm struggling to understand why. I mean, you can put anything in a trust agreement, but I don't think it would have any reasonable impact in an irrevocable trust.
All right.
Well, I take that back. What you can have. Oh, so let me go down that road for a moment. Let's say you have a piece of property, you want to deed that property over to the trust. Okay. Remember, the trust is a legal entity. So let's say you have multiple owners of that property. Okay, you're one owner, and Joe Blow is the other owner. Okay, you're creating the trust. You're going to deed your interest over to the trust. Okay, if Joe Blow dies and there's a right of survivorship, technically his interest should now go over to the trust. So it's not necessarily that the irrevocable trust is that it's the title to the property that you're dealing with.
All right. Do you need an attorney to establish an account for a it's not clear. Do you need an attorney to establish an account, a trust? Um,
I would highly advise getting legal counsel to set up either trust, irrevocable or irrevocable.
all right. The Sharon, if you would clarify this question, I think you left out a word. And while she's looking that up, let me go back up. If a person is receiving a portion of their deceased spouse's Social Security, will they be able to receive Social Security based on their own earnings when they reach the age of eligibility? Or
Yes.
will they lose the Social Security they were receiving from their spouse?
I don't have the exact answer to that. My understanding is that you can continue to get double your spouse and your own Social Security. If you don't mind, I'll try and look that up and give a follow-up answer because I don't know that's the exact answer.
Based on my training, I think that they need to go to a Social Security counselor and their Social Security specialists who provide special counsel in there, because they can actually guide them on how to maximize their income when they have a situation like this. I don't know how it's going to work, but I do know that when this comes up, we send them to a Social Security counselor. All right. Somebody has they raised their hand, but we can only receive questions or comments in the Q&A box at the bottom. All right. I think that's what I have. Let's go and discuss the next section, digital wills, ethical wills, and preventing elder abuse.
Right. So this area is becoming. I'm the view is approaching crisis level. Okay. Um, on so many avenues. Elders are becoming an highly likely potential for abuse from scams and phishing. To just show you, the worst case is one of the worst cases I've had. I just started. A person came to me. One of her family members was living alone. And a signal that you ought to be looking out for is when some elderly person suffers a deep traumatic event. In this case, this lady only son passed away. In another case I had, her husband was killed tragically. So when an elder person suffers a deep traumatic event like that, somebody ought to be keeping eyes on them. Okay. Um, anyway, this lady went into dementia, deep dementia. Vagrants moved into her house. She invited them in. I don't know if she invited them in because it's not clear that she was of sound capacity, but at least she didn't call the police and get them to move. So for over a year, these people living in her house allowed her house to basically go to trash, cluttering and damaged. So finally, I got involved. We opened up a guardianship case, and you have to have various people become involved. When when those people walked into the house, they immediately called the police and the code enforcement. When those people drove up to the yard, they immediately condemned the house because how damaged it was, and they got her out of the house because of her health. It was just that bad. The other situation, this lady had cluttered so much we couldn't get in the house. She had to move into another place, and these people were allowing her to stay in this place. Anyway, I'm sorry. I digress. Um, but anyway, this is becoming a crisis. I can we're going to have to form villages again, particularly in light of what's happening with Medicaid right now. We use technology, use every means possible to keep eyes on our elderly because it's this uh, they're predators abound. So be aware of the circumstances. Uh, Many instances, these people don't want to acknowledge that they're in decline. So take them to memory care facilities, help them to see how things are going on, and if they won't, if it's clear that they're a danger to themselves, you can report them to the court, or you can get an agency to get involved. But you got to get some official documentation that the mental capacity is in decline. Okay. Um, so how, how do you do this? How do you get the information? That's a critical thing that so many people they don't know how to get the information. Now we go back. If while they had capacity, they signed a durable power of attorney, that agent can get this information. They can go to the banks and find out if something suspicious is going on. They can go get their phone records to see if something suspicious is going on. They can look on the online and the digital and the social platforms. But I'm beginning to believe that it's critically important to do. Uh, and if they won't let you to do it, at some point you may have to. And it's clear that they're being harmed. There's something called a limited guardianship. Okay, normally when you hear guardianship, most people think of it's called a plenary guardianship, where you go to court. You make a case to the court. This person is completely incapable of making decisions, and they're harm to themselves and others. And then the court would basically take away most of their personal rights and appoint somebody to be what's called a plenary guardian. Well, if they're kind of middle of the road, they cogent, they could get about, but it's clear that their judgment is off and getting worse. Then what you can do is something called a limited guardianship, where you go to court and you make the case, but you don't take away all their rights. You leave them some rights. Uh, but you definitely get the ability to monitor what's going on in their affairs. Okay, so there are hotlines out there, but unfortunately, the way the world is today, these agencies are overwhelmed, and for them to get deeply involved at this level is tough. But be aware of that. So one of the things that I'm getting to recommend to people is um, there's this concept called a resilience hub. This is just emerging. And I'm recommending this thing called a faith-based resilience hub. Most churches are already wired and connected in the community. Okay, they know who's who, and sometimes they know what's what. Okay, that connectedness, I'm of the view, is critical right now. Okay, not to become overburdened, but at least for there to be some way of being connected to people. Um, and so using technology, using resources under the money that was in the Biden administration, there were going to be systems set up where you could do this. That's uncertain right now. But I'm recommending more and more that we figure out ways, techniques to become a village again, in particular to the vulnerable, to figure out how we can deal with what's going on. There's some avenues out there. Let's talk about first is digital will. So most of the will processes that I've talked about earlier are written hardwired wills, but these are becoming more popular where you can do it in a digital format, and it can be easily managed and transferred in a digital format. Um, you can This is important because nowadays there are a lot of assets that are not hardwired. They're digital assets. So here you can manage both your physical assets and your digital assets in one place. Okay. This I'm really excited about this. This is an idea. Remember, I talked about earlier when I started that so much of how we think of this process has to do with how we feel about ourselves and our circumstances. Well, the point of contention that I've seen time and time and time again when I'm dealing with these issues, it comes to a head when the elderly person is clearly now reaching or beginning to show indications of diminished capacity. Well, the children see this. If they're not connected and not engaged, the first thing they want to do is figure out a way to get them to deal with them. And more times than not, that way is to put them in an adult care facility or the nursing home. That strikes the death fear in the elderly people. They don't want to leave their homes, and it becomes a war. And I've seen some instances where it accelerated the mental decline. Just that tension about whether or not they can stay in their house or not. With my own grandmother, that was an issue. One of my brothers, to this day, I hold him in high respect. We were all living away, but he was near her, He took care of my grandmother for a long time to allow her to stay in her house because she was so against going into a nursing home. So here's what you do: you sit down while that person is in cogent mind, and you say, "Hey, we want you to be taken care of. We want you to be in the best set of circumstances. But here's what this entails. This you can't just do this out of dust. We got to do these things in order to make sure that you can stay in your home as long as you can. And here we got to put a bank account in place so that somebody can take care of you if you can't, with and we got to do these things so you do that in an ethical will. They say what they want to have happen. They say what they want their values to be. And then the real thing I like about it is this ever plan resource we're going to talk about is they can begin to talk about and bring value to their life. They can tell what the value of their life and what things they got out of life. Not in a apocalyptic way, but in a celebratory way. They can celebrate their life and what they've gone through. I always want, in particular, and all my friends at our age, when I send them a birthday greeting, I say enjoy the journey, because it's a journey, and we had a wonderful journey, and we're now approaching the end of that journey. Um, and you don't need to be afraid for that. Hopefully, your faith is intact. Your beliefs are intact. Document that. Document how your faith has grown, how your beliefs are intact, so that you don't have to be afraid. Your family members don't have to be afraid. They don't have to go through deep grief, although there will be grief, but the grief of absence or loss. So that's what this process is about. Some resources for you. I highly recommend the AARP Advanced. They have a whole resource book about estate planning. Very helpful resource. I encourage you go ARP. I think it's listed on the estate planning. The post forms are good. I'm just getting to know those. We talked about 5 wishes. So the master coordinator here, Mr. Norman, has set up some downloadable resources. If you click on this uh, QR, I'll leave it up for a few minutes. It should take you to a link where you can download some resources. And there are probably more out there. This is just something we've identified for you. Highly encourage you to take advantage of all of those that you can. And then also, if you get seek advice at every turn before you go up and try to do something that's going to have any level of sophistication. I love the ever plans. I found them to be. They have a couple resources that are really good. One of them allows you to document all your digital accounts. I got to do that this week. So how you get into your bank accounts digitally? How you get into my computer? A lot of my cases are only on my hard drive. So if something happens to me, my clients need somebody to help them out. Nobody can get into my computer unless I write this down and somebody can go and find their files. There are other resources that I highly encourage you to look at. These are some other resources that are out there, some free downloads. You take a picture of this and go look for these. I think some of them are on that list, on that download list that Steve has set up.
With these downloads, if you will, when this is over, I'm going to send you in the next day or so, send to everyone who attended a follow-up letter. In that letter, there will be a link to a folder where you can download each of these documents and more documents: advanced directive checklist, a caregiver's handbook, a checklist for hiring an in-home caregiver, life planning, frequently asked questions, power of attorney checklist, digital will checklist, ethical will checklist, and several other documents. There are approximately 10 documents that I'm going to send to you totally free. Now, we do have some questions that we need to address.
All right, let's go.
All right. The first one that I want to go back to is an attorney necessary to establish a trust account?
again, I highly encourage you to seek legal advice if you're going to do any kind of a trust. Uh, for several reasons. Number one, a trust has to have a high level of formality in its execution, just like a will. So in many states there are laws that govern uh, whether or not a trust is effectively and adequately drafted and executed. So you want to make sure you cover all those bases. Don't want to think you got something done and you didn't. Second thing is you when you put directions into a trust agreement, you need to be sure that you understand what the impact of those directions. Um, uh, if you because when you're going to appoint a trustee who's going to actually be the manager of everything that's in that trust. Most states have laws that govern the powers and duties of a trustee. You want to understand. You don't want to put something in a trust that the state law says a trustee can't do because that would invalidate that particular instruction in the trust anyway. So you want to understand what the duties and legal standards are for how a trustee can act. And then lastly, once you get the trust agreement all nicely done and set up and you execute it, it's a legal entity. You got to go get it. It's a legal entity. You got to go get a tax ID number for that trust. Okay. And then once you get a tax ID number, then you got to what we call fund the trust. Every asset that you want to be managed under that trust, you actually have to transfer the title of that asset into the trust. So every piece of property that you want to be managed under that trust, you got to do a deed from the current title and to the and with now naming the trust as the owner of that property. If you wanted to name a financial account, you got to go to that financial establishment and change the owner of that financial account from where it is now to naming it as a trust as as the owner of that financial account. Up and down the line, you want to make sure you dotted all those I's and crossed all those T's. It's not it's not just a simple little deal to set up a trust. So I highly recommend you get a legal counsel.
All right. There was a You used a term earlier that some were not clear on. Uh, but I think it's when you were talking about tenancy the entirety. Would you simply mention that again and help them understand that what you were saying was tenancy by the entirety?
That's correct. Tennessee by the entirety. Or some places they say entireties, plural.
All right.
So again, this conversation only comes up when a married couple acquires property as a married couple. So you buy a house, and on the deed it says two husband, to the two people, comma husband and wife. Or you open up an account, and it says two people, comma husband and wife. This conversation only comes up when a married couple acquires property as a married couple. And the way the law
Okay.
works in most states is once you take that title, it's not like two people own the property. It's as if one person owns that property. So if one of the married spouses passes away, the title this it really has to do with the title to the property. The title to the property is not affected because in the terms of the law, only one person owned that. So one spouse passes away, it now remains in the name of the surviving spouse. Now that surviving spouse no longer has tenancy by the entireties because there's not a husband and wife anymore. Now, let me give you this situation. I'm dealing with this right now with a good friend of mine. And I didn't know this until after he passed away. So he and his wife bought their house, husband and wife. They got a divorce, but it wasn't a real divorce. I guess they were just mad at one another for a while. And my understanding is they stayed in the same house, and then they got remarried, never having left the house. My understanding, and I've done the research, it's pretty clear now. When they got divorced, the tenancy by the entireties went away. Okay. So when they got remarried, and this is in Florida, they got remarried. That the house. I'm sorry. Let me go back for a minute. So when they got divorced, and the divorce decree didn't allocate or transfer the title, the property at all, they now own that house as joint tenants, two different people. Okay, that was, as I said earlier. Now it's two different people own the house. Each one has their own line of ownership. When they got remarried, that remarriage did not reestablish the title by the entirety. When they got remarried, the house title now is still joint tenants. Okay, so when one of them passed away, he now owns his one half of the title goes to his heirs. But the heir, luckily, he's still married. He was still married, so the heir is his surviving spouse. So luckily, she gets it, but not by tenancy by the entirety. She gets it because of the transfer of title upon his death, which in this case he didn't leave a will, was by the intestate statute. I know there's a lot of legalese. Main point: tenancy by the entirety only occurs when a married couple buys property as a married couple. If you get divorced, tenancy by the entirety this goes away. Okay.
All right. We've got another question that's going to probably be very much related to that. What if all property was purchased before marriage?
Then it's in the name of the person who had the property going into the marriage.
All right.
Now, I've
Go
seen
ahead.
this again. This blended family thing is interesting. If you want that to become property by the entirety, you got to now basically take the property that was owned by one spouse. You now have to sell that property to both of you as husband and wife. You can do that. That one person can deed that property to both of them as husband and wife. That creates a tenancy by the entirety.
All right. Next
You got to
question.
do that. You got to do that deed. You can't just say it.
Oh, okay. Do you have an opinion on organizations such as trust and wills in setting up either a irrevocable or vocable trust?
So normally I recommend a revocable because we're fickle and we'll change our mind. Um, uh, and then, but at one point I forgot to mention once the grantor is the person who basically creates the trust and transfers property into the trust. Okay. Once the grantor passes away, or if there's multiple grantors, when all of the grantors pass away, that revocable trust automatically becomes irrevocable. In other words, you can't change it after that person dies. The grantor dies. So, um, so normally what that means is, in terms of revocable trust, if you want to keep control of the property while you're living, and you want to have some control of the property once you pass away, then you can do a revocable trust. Okay, and then you identify what happens after you pass away in the revocable trust. If you want to do an irrevocable trust, you can do that. And there are some applications where they require you to do irrevocable trust. I would only do it if it's required. Okay, classic example of that is the special needs trust. Okay, a special needs trust has to be done as an irrevocable trust. Remember that special needs trust is when somebody is in Medicaid and they get a new infusion of special unexpected infusion of money, and you got to create that to keep them on Medicaid. Well, the Medicaid provisions require that trust has to be irrevocable.
All right. If in your will you leave your home to a relative and you die, but the home still has a mortgage and no mortgage insurance to pay off the loan upon death, can a relative go to the bank which holds the mortgage and offer to purchase the home?
Okay, let me make sure I understand what you're saying.
All
So,
right, I'll read it again.
okay,
If in your will you leave your home to a relative,
okay,
you die, but the home still has a mortgage and no mortgage insurance to pay off the loan upon death.
Okay.
Can a relative go to the bank which holds the mortgage and offer to purchase the home?
Okay. So let's take that in piece parts. So you own the house, you pass away, that mortgage is still in the name of the person who passed away. Okay. That mortgage was acquired based on the collateral, and the guarantee on that mortgage was based on the circumstances of the person who passed away. Okay, so almost always the bank is going to want to refinance that note. So if you in your will uh, directed that somebody get that house, they're going to have to figure out how they're going to take on that mortgage in order to keep the house, even though it's in your will. Okay. Now, if a separate person, if even if it's not a relative, they can come, you get title. You get now remember, you get title in the probate process. So they transfer title to the house subject to the will under probate. So you got title to the house, but now the bank is going to be looking to say, okay, can you take over this will? I'm gonna take over this mortgage. I'm sorry. If you, and the way they can tell that is if you refinance that note, they're not going to let that note go on very long in the name of the person who passes away. They're going to approach you and say you got to refinance this note in order to keep title in your name. Okay, that's a weird little deal, but that's just the way it is because they got the lien. So the person who got the title to the house in the will can now refinance the house and keep title in their name. But if they can't afford to refinance that house, they ought to absolutely seek out somebody to buy the house. Now they can sell the house because they got title, but they got to sell the house in order to pay off that mortgage. Otherwise, they're going to force that. So you obviously that you would hope that the house would be worth more than the mortgage balance. So if the person who got the house in the will cannot afford to refinance that house and keep it in their name, the immediate first thing they ought to do is seek a forbearance and then try and sell that house out of probate or just after probate. Don't wait until you can't afford the mortgage.
All right. Please explain right of survivorship again.
Hey, Lena, I'm doing this webinar. I gotta hold you back. Right. Say again.
Please explain right of survivorship again.
Okay. So right of survivorship is this conversation comes up when you have multiple owners of an asset, most often real property. So you have uh uh what's the three shoes out? I'm trying to think of the three shoes' name. Larry Moore and whoever the other guy is. Um, they're joint owners on a piece of property, and it's called joint tenants. So they have each their own right of ownership. Not and if one of them dies, why none of them can do anything with the property unless everybody agrees. So they don't. That's why they call undivided. So one of them can't go off and sell the property alone. The only way that property can be sold is all three of them sign on the dotted line to sell it. Okay, but they each have a line of ownership because they have a right to that undivided share of title. So if one of them passes away as joint tenant, then their estate owns their share of that title. And either if they did a will, then their will would dictate the transfer of their share. If not, again, intestate would dictate the transfer of their share. And the other two, if they're still alive, they still keep their share. But the state of the other one, that's why you'll see sometimes you look on the property appraisals, you'll see two or three names and then their state of. That means there were multiple owners. One of them died, their estate still owns their property, and the other folks are still living. Okay. Now, contrast that if you have on the deed when Mo, Larry, and the other guy took the property, if on that deed it said right of survivorship and one of the three died, then what happens there is the one who died share of the title does not go to his estate and to his heirs. It is what we call it lapses, and is now only that property is now only owned by two people, the two people that remain living. So where you had three shares, you only have two shares left. And then if the next one that dies, their share lapses, and now you only have one remaining share. The two that pass away, neither of their estates, neither of their heirs can take advantage of the rights to that property.
Okay. We've got a few more questions. Some of them are going to be answered in the downloads that and documents that we sent we're sending you. But I want to take we've got maybe 17 more questions, but we're down to the end of our time. I'm going to take 3 or 4 more questions, and then these are questions that will not be answered or dealt with in the um, in the materials that we're going to give you.
Right.
All
And
right, but
I'll offer this: if the ones that we don't get to, uh, if you shoot them to me, it won't be. It'll probably be next week. I'll try to get you some answers though that can be sent out.
all right. Also, let me the I want to thank Attorney Ennis, I mean Attorney Jacobs for doing this, and he's made a special offer um, that for a limited amount of time. I think that, and he can tell you when he wants to set this up. But the you see his his he's willing to allow you to call him and get free information for a very limited amount of time. This is a very valuable opportunity. I would suggest that you take your phone and take a picture of his contact information on the screen and contact him directly. And if it's something that he can answer that is not state specific, then he will do that. If he may tell you, give you some general counsel and suggest that you speak to someone in your state. A couple of more questions that I think that we have not we have not answered anything from these persons. All right. Two siblings have power of attorney for each other. One sibling dies. Can the deceased sibling's child, whose name is not on anything, come forward to try to claim uh, their parents' property?
Okay, so remember, a power of attorney is only a direction that allows the agent named there to take care of affairs of the person who's not able to. Okay, so if one sibling has power of attorney for the other sibling, all that means is that one sibling can, if that person can't go to the bank, they can go to the bank and take care of affairs for them. They can go pay the light bill. They get by being the power of attorney, they get no rights to any property or any asset. If they do a will that says that, then that's a different story. But on the power of attorney, there's no rights to anything. And remember, once that person passes away, the power of attorney is gone. There's no authority on the power of attorney issued once that person passes away.
All right. Now, here's another one. I read a case of a person who was in their right mind and their adult children wanted to have them declared incompetent so that they could gain control of their parents' assets. What protection is available for the elderly parents?
Very simply, you go to a psychiatrist and let that psychiatrist give you an evaluation that says you are competent and capable. And if they
All right.
go to court, you enter objections to any petition. So normally the way a guardianship case works is somebody files a petition that alleges that you are incompetent. Okay. Okay. And then in Florida, once that petition is filed, the court requires that 3 people get appointed by the court, independent people. And normally those people are they're on a list that the court maintains. It's not somebody that those children can go find, but it's on a court that it's on a list that the court maintains. So you have to go pick 3 people off that list. Those 3 people have to go interview that person, and all 3 have to conclude that that person is incompetent. I don't know how I'm not aware of many other states and how they do that. But in Florida, that's a safeguard for something like that. So, but then if all those 3 experts come back and say that you're incompetent, then it very well could be that a judge will enter an order. But you have the right in Florida. normally the person would is a person who wants to get you declared incompetent. They would hire me initially. So I'm the client. I'm the attorney for the petitioner, the person that wants to get you declared incompetent. In Florida, before anything can happen, there has an attorney has to be appointed to represent the person who is the alleged incompetent person. Okay, so that before anything can happen, I have to coordinate and normally these attorneys are again on a list maintained by the court. So the children can't go find a lawyer that they want. You have to get somebody on the list that the court maintains as the attorney for the alleged a competent person, and that attorney has to show up in court on your behalf. So in that case that I mentioned a little while ago, um, the attorney that we got hired, that's the attorney who went over there to the house and found out the situation is so bad and called the police. And has been monitoring the case to make sure that nothing happens that this person didn't want. In another case, and the other, in fact, there was the other case that I mentioned where there was loitering. I'm sorry, cluttering. Uh, that lady was fairly cogent. She understood. She wasn't like walking around, and so those three people said, we don't want this to be a plenary garden. Remember, plenary is where they take away all the rights. The three person, they call it examining committee, came back and said, this lady ought not have all her rights taken away. She should only be subject to a limited guardianship. And that's what was ordered. Whereas the person who filed the petition was asking for a plenary guardianship. And so you should find every safeguard possible.
Okay. There, two or three people want to know about the digital assets again. The digital assets uh, are your online accounts, bank accounts, and social media. You want to leave some instructions on how to handle these. Also, it can be digital devices, such as iPads, iPhones. I would suggest there is a document that I'm going to give you that has a checklist that you use for your digital assets. When you receive that, go through that. It's extremely important. I've personally worked with a family whose father iPad, when he died, no one had the password for his iPad. Apple would not allow them to have access to it. All right. What the one final? Okay. Well, a person wanted to say, what was that again about faith based? I think that's when you was talking about the resilience hub. And would you say a little bit more about faith based resilience hub? And then we have one other question.
Right. So again, excuse me, this is an idea that's really just emerging. And for that reason, what the understanding of it varies around the country. but generally, it's the idea that you would have a central format or platform where there's awareness and connectedness for the vulnerable in the community, and you bring resources to those vulnerable constituencies through this avenue, through this platform, through this hub, if you will. There are instances where the churches have been the lead on that. And my proposal is that we need to bring some definition and structure to that. One instance, I kind of got involved in it because I have some background in energy, as was mentioned. So there's a church, I believe it's in the DC area, where they put a solar system on their church, and that solar system winds up saving them money. That rather than taking their savings from that and putting it into the church budget, they're putting those savings into a benevolent fund, and they're doing things in the community to support the community from those savings. So a church could put up again, this was under the Biden money, where there was some real easy avenues to do this. They could put up on, and this is going to become more and more important because of the heat, putting up a solar over the parking lot, array over this parking lot as shade, but then saving money with that, and then using those for resources. But then additionally, we're seeing more and more climate events. So storm comes through, whatever, fire. Normally, underserved communities are some of the last ones to restore power. Well, if you have a solar system, you're gonna get your power back up. People can come there and charge their phones. Get them if the medicine needs to be refrigerated. They can come get refrigerated. They can come. There can be a place where meals can be brought. A central location where meals can be brought. So that's the idea of it. Now, in terms of estate planning, what I believe also can be happening if you have disposable income or some disposable resources, you can begin to direct your, just as churches now select people, ask people to do charitable giving through trust and such. Well, you can do the charitable giving and direct it to this resource hub, kind of an idea.
Okay. One last question, and well, and then we need to emphasize something. First, I want you to emphasize this. You mentioned about the necessity of funding uh, the trust. The I think we need to go back and, as Elder Bradford said, put the emphasis on the proper syllable.
So again, when the idea of a trust is you're creating a separate legal owner for an asset, whether it be property or tangible assets. And so once you go through the formality of getting a document done and all that, that's just an empty bucket if you want to look at it that way. It's just sitting there. And I've seen trusts that have been created, but nothing was ever put into the bucket. So it never has any authority to do anything. It only becomes a real deal once you transfer title from an asset from a live person into the trust as the owner. Okay, that's what we call funding the trust. So in the case of a piece of property, you would do a deed and transfer the deed, and then deed would transfer property from the name of a person and list a grantee on that deed as the name of that trust. Okay, same thing with a bank account. You would go to the bank and you would transfer the name from the title of that or an investment account, from the title of that to the name of that person to name that trust as the owner of that account. That's what we call funding the trust. And from that point on, the trustee is not the owner of the trust, but the trustee is the only person that has rights to manage that trust as if it were the owner. The trust itself is a separate, it's an entity that owns the trust. But a legal document can't walk into a bank and sign a document for that asset. The trustee can.
All right. The Another question, the last question is, how are thieves stealing people's homes, and property, and is there an insurance to protect their property?
Wow, that's a good question. Uh, it's a challenging question. So what happens is, uh, I thought I wasn't aware that it was as easy as it is, but it sounds like, and I have a case right now that I think it happened in. Somebody can walk into the courthouse and present a deed. Now, that deed should only be effective if it's confirmed that somebody who is the owner of that property signed that deed, because that's the only person who should be able to transfer a title. Okay, so the deed should only be effective if somebody who's the current legal owner of title executed that document and filed it. But sounds like there's what's happening is there's forgeries going on. There's some of the processes, and maybe even digital forgeries, where a forged deed is now being entered to transfer title to the property. Okay, and 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 unless you go to the courthouse, they don't give you notice that happened. So there are now services that are coming up. You need to even research these services and make sure they're legitimate. But there are now services that are popping up that will bring you notice if some kind of transaction happens to the title of your property. So what if that you get a notice like that? If somebody signed it, you should immediately go to the courthouse and inquire as to what documents were done. Okay, and if those documents are not legitimate, you should file a court case. That's unfortunate, but that's what you got to do. The court case is called quiet title. Okay, if somebody's it's filed some document and it's not legally or it's forged, they're going to accept that document. They may have challenged it, but too many often with some finding too often the courthouse will accept those documents as if it's a legal document. So now you have what's called a cloud on your title. So you need to file a legal case called quiet title, where you challenge that document was not legal, not effective, and that they and the remedy of that court case is that title should be now clearly resolved to you, that remove any clouds. They call it quiet title again, but basically mean removing any clouds that are not legitimate away from your title and now restore it into your name. I don't know any other way right now of doing that. Hopefully there'll become some simpler ways where you can show that it's illegitimate and they'll automatically remove it. But I'm not aware of that many processes right now where that happens. So what I would recommend is finding some service that will alert you if something happens to the title to your property, and then you investigate that immediately. And if you confirm that there's something going on, you file a quiet title action immediately.
Okay. Well, thank you. I want to say that we really appreciate the wisdom that you've given us. I want to say now in closing that that we thank you, everyone who attended tonight. We hope that this has been very beneficial to you, and that you will be able to use the materials that we make available. This is the first of a of these type of webinars that I intend to sponsor. Back in 2007, I became a certified senior advisor and have been doing things with that in various means. But right now, I want to sponsor webinars to help. We're now have begun in preliminary discussions to bring a person who is a financial planner. We would like to also bring somebody who will discuss Medicare and other issues. If there is a topic that you would like to see us do a webinar on, please email me at stephen.norman3@gmail.com, and we will see what we can do. I don't think we can do any more than about 4 per year because there's a lot of preparation that has to be done. But and you will have enough homework now after this that you're going to be busy for the next 3 months. And my wife and I have completed most of this, but I would suggest even if you have your trust done, go back and review it. Check. I made a few notes here for myself to go back and check because there's some ideas here that I don't think that we took advantage of when we did our work. You also need to update your digital will on a regular basis. You need to update other aspects of your estate planning. You may have to update your power, who has your power of attorney. Go back over all of these things at least once a year and to be sure that everything is up to date. And now I'm going to turn it back over to Ennis Jacobs just in case he has any closing remarks.
Well, again, I want to congratulate you for taking this focus, being this concerned, and take this time. It is incredibly important, and I'll end with the story that I think epitomizes the worst of these circumstances. Court case came to me. I think I mentioned it earlier. It was a blended family. Yep, guy married, had a daughter, divorced. Or actually, I'm sorry, the first wife passed away. No, well, anyway, and then he remarried. The daughter of the first marriage and the wife in the second marriage were absolutely at odds. Um, he did the original house, the original homestead. He wanted the first daughter to have it. Okay, so he did a life estate deed Remember what that is. Where you while you cogent and incompetent, you do a deed that says, I'm gonna have this on this house for all the time that I'm living. And then when I pass it away, it immediately goes to the person who I name in this deed, what's called a remainder. He executed that deed, filed it. It was on record. He gets married to the second wife. She's offended that she doesn't get the house. She puts, I'm told, put tremendous pressure on him, which may or may not have an impact in his going into dementia. And there was some indication that dementia may not have been legitimate. He may have been playing to be in dementia. So, long story short, he won't sign away his daughter's interest in the property. Second wife's son of her prior marriage, decides he's going to take matters into his own hands. And some way, form, or fashion, a deed appears. That's why that last question was so interesting. Some way, form, or fashion, a deed appears where this gentleman supposedly signs away his daughter's interest in the property with that remainder interest. He stays on as the primary owner, but by signing away his daughter's interest, guess who becomes now a co-owner of the house? Second wife. Of course, war breaks out. We had to file a court case to quiet title on that deed. Basically, we challenged and we basically proved that he either was not aware or he was playing like he was in dementia, and that deed was never officially executed. And we were successful in getting the court to basically reject that deed, and so my client, the first daughter, reclaimed her interest in the house. That set off war of thermonuclear war. The second wife would not allow her to come to the house. She couldn't visit her father. It became incredibly contentious. She called the police, the whole 9 yards. But now, because he's supposedly in dementia, he can't do a will. So she grabs all the money from every account she could find. And we couldn't, now we can't, because we can't show whether or not she did it, it was done by him or not. I can't tell you how contentious that situation is. That's the kind of confusion that can come up if you don't do this kind of planning. So again, I want to congratulate you all. I want to implore you to have life and have it to the full for all of your life. Take care.
We thank you. And until we meet again, God bless.
God bless.